It is my pleasure to introduce our keynote, David Bilchitz. And let me tell you a little bit about Professor Bilchitz. He is a professor of fundamental rights and constitutional law at the University of Johannesburg and director of the South African Institute for Advanced Constitutional Public Human Rights and International Law. He is also a part-time professor of law at the University of Reading in the United Kingdom. He was appointed as an acting justice of Constitutional Court of South Africa from February to May 2024, and this was the first full-time academic to have been appointed directly to act as a judge on the court in over 20 years. He was the Secretary General of the International Association of Constitutional Law from 2013 to 2020, and he is now a Vice President of the association. He was also the chief organizer of the World Congress of Constitutional Law, which brought constitutional academics from around the world to Johannesburg in 2022. Professor Bilchitz has 2 monographs, 5 co-edited books, 1 textbook, 29 chapters, and 41 journal articles. In relation to animal law, Professor Bilchitz has written several seminal articles that consider the possibilities that South Africa's new constitution provides for a change in the status and legal entitlements of animals. He has also sought to put his ideas into practice. He is the director of the Animal Law Reform South Africa, which seeks to shift the approach towards animals in South Africa. He's played a role in the moratorium on elephant culling and has been involved actively in trying to change the plight of animals in South Africa through parliamentary submissions and litigation. He also co-taught the first course on animal law in South Africa. And with that, welcome, Professor.
Thank you very much, Pamela, for that generous introduction. And it's wonderful to be with this group and to be also now the University of Johannesburg and the Institute I direct to be one of the collaborators in creating this wonderful workshop. So I'm just going to add on, here we go, PowerPoint. There we go, brilliant. So I hope everyone can see the PowerPoint. Yes, I'm seeing Simon is nodding, so that's good. So I'm going to start with a quote, which was emerges from a fantastic speech by the Deputy President at the time of South Africa, Thabo Mbeki, on the passing of the South African Constitution. And he said, you can listen to the whole speech. It's called I'm an African. It's very, very powerful speech. And he, as part of that poetic speech, he says the following: at times and in fear, I have wondered whether I should concede equal citizenship of our country to the leopard and the lion, the elephant and the springbok, the hyena, the black mamba, and the pestilential mosquito. A human presence amongst all these, a feature on the face of our native land thus defined, I know that none dare challenge me when I say I am an African. So in this quote, Mbeki suggests that a defining feature of Africanness is sharing the land with other creatures. He conjures up an ethos not of domination, but of mutual respect and cohabitation with other creatures. Indeed, far-sightingly, he suggests the conferral of equal citizenship upon non-human animals, a suggestion that many of you will know has only quite recently been defended in the academic literature in Zoopolis. African societies have, of course, lived with animals over time, right, over centuries and millennia, and it's important to return to this ethos that was challenged by colonialism. In the colonial authorities adopted particularly a dominating approach towards other animals and came in with hunting parties, etc., killing both humans and other creatures. And that idea also enshrined itself very much in international law, which drew on the notion, and still does, of animals as commodities. Now, despite there being a lot of pressure to include animals as rights bearers in the South African Constitution. Unfortunately, no express mention was made of non-human animals in the Constitution, except in certain schedules dealing with the competences of the various government bodies. That does not mean, however, that animals are excluded from all protections. And the question arises, what are the implications of some of the existing provisions of the Constitution for animals? An important background point is also to say that the new constitutional order in South Africa that came about in 1994 fundamentally sought to change the South African legal order from an unjust system to something better that enshrines social justice. And so, given the importance of the Constitution and the shift it brought about in South Africa, it raises a real question about what changes are meant to occur in relation to non-human animals in the country and the legal framework governing them. And so in this presentation, I'm going to tell you a little bit about the history of the status of animals in South Africa. Some of this is not that different from any other countries. We'll consider the effect of animal welfare law, the shift brought about the Constitution, and some of the exciting developments. So for many people, this will be quite informational in many ways. And then the need for some of my other writing is more normative in some ways, but we don't have time to do that today. And then I will consider some exciting developments around the need for concretization of respect for animals with certain statutory reform initiatives that are currently underway. So, a very brief history. South Africa is the cradle of humankind. If you visit the area around Johannesburg, it's the area where some of the transitional hominids existed between apes and humans. And ultimately, the fate of humans and animals are fundamentally intertwined. African philosophy includes an idea of Ubuntu, which essentially talks about the way in which we exist in relationship with others, and speaks about the need for harmonious interrelationships between ourselves and others. Now, of course, African peoples lived with animals around them, and of course, one shouldn't present the idea that there was no conflict. There were conflicts, of course, between wild animals and human communities, which exist today, and there was also the keeping of animals as farmed animals as well. In South Africa, the Dutch arrived in 1652, and then later the British. And the view of the colonizers, as I've already mentioned, was a view of really dominating over the peoples who were living in this area. And it included a view of human superiority over other creatures. And I told you a little bit about hunting parties that went out to shoot every creature in sight. And that led to a drop in iconic numbers of species such as elephants. Racial segregation was a feature of colonialism, but it was enshrined in very specific laws from 1948 onwards with a system of apartheid, which forced black and white people not to marry, to live in separate areas, and basically enshrined a system of consigning black people to an economic underclass, and ultimately a system of discrimination. And as well as that, there were other forms of oppression too. The system enshrined sexism, homophobia, and high degrees of poverty along lines of race. So the constitution in South Africa was designed after there was a whole struggle, and we don't have time to go into the history, but that's ultimately to transform this existing situation and to move the society against this backdrop of severe racial inequality, to change the past into a future essentially that enshrines central values of dignity, equality, and freedom. And that required a shift in the law. And so there's a requirement in the Constitution that when interpreting any legislation and when developing the common or customary law, every court, tribunal, or forum must promote the spirit, purport, and object of the Bill of Rights. So there's a strong interpretational duty to advance the underlying values of the Bill of Rights and also to consider international law. So the question is, how does this apply to animals? And this is an important question because it also is important to recognize the deep levels of oppression of animals over time in history and currently still. And so to understand that, we need to understand a little more of the history of South African law with regard to animals. So, of course, this is very common in many legal systems. We have a system that derives, at least from the colonial times, from Roman Dutch law. And the law of persons defines a person as a being or entity or association which is capable of having legal rights and duties. Being a person means you count legally. And natural persons are defined as all and only human beings. And then there are also certain legal persons, like companies, which are essentially fictional persons. What about non-human animals? Well, they traditionally classified as things or property in the law, like many of the legal systems you're familiar with. Their interests are not considered in their own right, and they're not entitled to the protections of fundamental rights and other common law rights. And so we have that weird anomaly where a company which doesn't really exist has more rights than an animal who's there simply to be used. Now, of course, that was the sort of position, and virtually anything could be done to an animal. But with the influence of British colonialism was also the influence of animal welfare legislation. As we know, the first animal welfare law in 1822, the Martins Act, and that influences various colonies. And the first early legislation is in 1874 in South Africa, and the Cape Province in 1875, where legislation is passed for the prevention of cruelty to animals. South Africa becomes a union in 1910, and the first nationwide law was passed in 1914. And when South Africa becomes a republic in 1961, there's a new Animals Protection Act, which is the current act at the moment. And the main offenses in the act are similar to other jurisdictions. It prohibits a range of acts that, whether intentionally or negligently, inflict unnecessary suffering upon animals. Now, what is the impact of the act on the status of animals? What does the act, in fact, do? Well, there's a dispute as to that initially in the case law. The idea was, does this act simply protect human or community interests, or does it protect animals themselves by conferring certain rights on them? And the early approach, the S versus Moatu case in 1947, said the aim of the legislation was clearly to forbid a legal person to act with such cruelty towards an animal that the finer feelings and sensibilities of their fellow humans would be harmed. Sorry. So the focus is not on the interests of the animals, but the focus is on not offending other humans. And of course, that's a ridiculous kind of justification in a constitutional democracy. Why should offense to others, if they don't like something, that shouldn't necessarily be a ground for a criminal prohibition? And there are many other reasons which we could critique this rationale of why humans count and why there's sort of some kind of indirect duty towards animals, because we really care about humans. And I won't go into the critiques because many of you will be familiar with that. Now, the important thing is that this approach has more recently been rejected in a 2008 case that dealt with a project that was essentially trying to save rare tigers from extinction. And essentially, it was found that live antelope were presented to the tigers to be able to essentially teach them how to prey on the antelope. Now, the presentation of live animals to predators is an offense in terms of the Animals Protection Act. And the court was faced with an application for an interdict to stop this behavior. And in order to receive an interdict, you have to show that it's likely that that behavior will continue in the future. And the individual basically said in court, I won't continue to do this in the future. There's no need for an interdict. And the majority of the court said, well, we believe you. There was no clarity as to what would happen in the future. And so they didn't grant the interdict. So that's a bad example of the majority in this case, but the minority was really important because Justice Cameron, who's a legendary judge in South Africa, he recognized that the views in that early case were erroneous. He said the purpose of animal welfare legislation is, he said, though not conferring rights on animals, the statutes are designed to promote their welfare. And the statutes recognize that animals are sentient beings that are capable of suffering and of experiencing pain, and they thus acknowledge the need for animals to be protected from human ill treatment. So he gave a rationale for recognizing that animals are capable of experiencing immense suffering, they have no voice of their own, and they deserve protection in their own right. And he found that there was a need for protection, for a voice for animals, and he said the societies for the prevention of cruelty to animals were essentially set up in South Africa as their guardian and their voice. Now, the minority, that affected the result in the case, because he said the refusal of this particular individual to say what happened to this antelope called a blesbok, and the assurance that it would not happen again, he didn't give a real assurance, meant that given that animals' interests needed to be taken very seriously, the interdict should in fact be granted. And we could not simply lie on someone just saying and expressing their intention that they would not harm the animals again. And so there was a difference in approach towards how seriously the interests of the animals were taken. The majority essentially found, well, as long as you say you're not going to harm animals, that's fine. But the minority felt there was a need for much stronger protection for the interests of animals. So the next major development that took place was a case in 2016, which related to a religious sacrifice of 2 camels in front of a crowd of people. Now, camels have very thick necks and very hard to actually slaughter, and what was happening was very terrible. And the National Council of the Societies for Prevention of Cruelty to Animals inspectors were there, and they regarded what was happening as seriously cruel. There were 8 attempts to slice open the camel's throat, and essentially the inspectors then shot the 2 animals to relieve them of their suffering. But they then wanted to prosecute the people who had done these things to the animals under the Animals Protection Act. And the prosecuting authority said, no, we're not going to prosecute. And the National Council wanted to institute what's called a private prosecution. And the National Prosecuting Authority refused to give them a certificate which is required to institute that. And they said that they're not entitled to prosecute as they are a legal person. And so the case really concerned whether they were entitled to prosecute themselves under the Criminal Procedure Act. And a significant finding was made by the Constitutional Court in this case that the act that existed governing, which is a strange feature of South Africa, governing the National Council of SPCAs, that enabled them to, in fact, conduct prosecutions, which is obviously very significant and important to enable a body that is designed and supposed to be focused on protection of animals to conduct prosecutions. Now, as part of reaching that conclusion, the court made a number of far-reaching statements, which essentially shifted the position of animals in South African law. They went through the history of animal protection, including the Openshaw judgment, which I told you about, the minority, and it then made the following groundbreaking statement. It said, therefore, the rationale behind protecting animal welfare has shifted from merely safeguarding the moral status of animals to placing intrinsic value on animals as individuals, right? So suddenly we have a notion of animals as having intrinsic value, who deserve protection in their own right. Intrinsic value is even linked to the notion of dignity. And so in some senses, the court is recognizing that animals have a kind of dignity, have a kind of worth in their own right. And that also means that when animals and humans clash, or their interests clash, animal interests are not just discarded, they have to be considered. I told you, however, that there was no animal rights in the Constitution, directly or explicitly. So where are animals in the text? Where did the court find animals in the text? Well, they found in the right to a healthy environment, okay, the environmental right. Again, some jurisdictions have followed in that respect. And it has also a segment that individuals have a right to have the environment protected for the benefit of present and future generations through reasonable legislative and other measures and there's a range of different things, but one of the elements that was recognized that promote conservation. It was interesting in this case, the court found, and this is that animal welfare was connected with the constitutional right to have the environment protected. And this is where, to some extent, I can claim some degree of credit, because I believe a paper that I wrote talking about what I call the integrative approach, which I'll outline now, of relating environmental rights to animals. The court drew on that idea, although they didn't cite me because my paper wasn't yet published, but I presented it, that the integrative approach, they said, correctly links the suffering of animals to conservation. And it said that showing respect and concern for individual animals is connected to broader environmental protection efforts. And animal welfare and conservation, it says, are intertwined. These were very, very important statements, which have actually led to a shift in South African environmental policy. The environmental policy had been, for a very long time, that environmental affairs didn't engage animal welfare at all. So how are we to understand what it means by an integrative approach? Well, I distinguish in my work between what I call an aggregative approach and an integrative approach, and I think that's what lay behind the court's reasoning here. The aggregative approach sees the focus of conservation as being on the species as a whole, and it allows for the sacrifice of many individuals for this wider goal. And the integrative approach focuses both on the survival of individuals and the species. It integrates a relationship of respect for individuals with the survival of the species. And if you're interested in more following through this idea and these arguments, that's the published version over there of my argument. So a good example here is trophy hunting, right? Trophy hunting is the shooting of animals simply for entertainment, right? And to take the trophy, the head of the animal, and put it on your wall or something, right? There's no other use of the animals. It's simply to shoot an animal for entertainment. This is a relatively big industry in South Africa. Unfortunately, it has continued in post-apartheid South Africa. In my view, it's inconsistent with the ethos of the South African Constitution. But those who advocate for trophy hunting argue that it benefits the species as a whole, because people come from wealthy parts of the world, from the US, from Germany, mainly from the US, in fact, and they bring in large amounts of money to the country, which partially can be put back into conserving the species. So you sacrifice some individuals, but you save the species. Moreover, it provides an incentive for people to protect the species in question as they benefit from the wildlife in the country. These views essentially are grounded in a utilitarian ethic, which justifies serious harm, death, often suffering to individuals, for the so-called greater good of the species or the environment as a whole or whatever. An integrative approach rejects the idea that the sacrifice of a range of individuals can advance the goals of species conservation. It argues that respect for individuals is essential to preserving the species as a whole. And there are various reasons, both empirical and normative, which I give as to why the integrative approach should be preferred, and why, in fact, the aggregative view does not achieve the benefits it suggests. It actually undermines the protection of the species as a whole by negating or undermining respect for individuals. As I say, I don't have enough time to go into that argument today. So which approach should be adopted to interpret the notions of conservation? And also there's another notion of sustainable use in the Constitution. The dominant view is the aggregative view. And until recently, the policy in South Africa was very much it was very much engaged that approach, and it still does to some extent, that ultimately the species should not be depleted. We need to ensure the species continues, but it doesn't matter if we kill many individuals or treat many individuals cruelly, as long as the species survives, right? The important point here is that the Constitutional Court, in fact, aligned itself with the integrative approach. That's the highest court, and it connected respect for individuals with conservation. And as I said, the focus being not just on the species, but on individuals as a whole. So how does this actually impact in reality? Well, I want to give you an example just to illustrate that from another case, right, which related to South African administrative law, which, as many of you are familiar with, it's a branch of public law which regulates the legal relations of public authorities. Okay, and it's enshrined in a constitutional right in South Africa. Everyone has a right to administrative action that is lawful, reasonable, and procedurally fair. And there's a specific act that gives effect to it. And it can be helpful in challenging government action relating to animals. Now, I'm going to show you a picture of the trade and the hunting in relation to lions and canned lion hunting, and I'm going to just, some people might get upset. So I'm going to warn you now that there's going to be graphic imagery. So I'll say, I'm going to show it now. If you don't want to have a look at it, turn away now. Okay. And this is showing you some of the trophy hunting. That's a killing of elephant, the breeding of lions, and here someone who's just killed a leopard and supposedly, just seeking to show how, how powerful or dominant he is. Now, the life cycle in South Africa, what's grown is an industry called canned lion hunting, which basically involves rearing lions domestically for shooting, like a type of a, not quite factory farming, but almost factory farming of lions for shooting. So they're basically domestic lions. They're born in captivity. They then are reared by bottle. Volunteers often come in. These places get money from it. They're used for walking with tourists. And when they're fully grown, of course, they're completely used to humans. They're connected with humans. They take them outside into the middle of the bush. They're not wild animals. And often what happens is a hunter comes with his big gun. They walk towards the hunter. They're not afraid, and the hunter shoots them. And then they sell their skeletons, essentially, in the lion bone trade, because some parts of Asia see lion bones as medicinal, right? It's one of the problems with rhino hunting as well. So this case related to the setting of quotas, of export quotas. Those familiar with the Convention on International Trade in Endangered Species will know that there has to be certain export quotas for exporting for something like lion bone. And the government had to set certain quotas. And in 2017, the quota was determined at 800 skeletons, and then it was doubled, right, to a year later to 1,500 skeletons. And again, the National Council on Societies for the Prevention of Cruelty to Animals said that the government had to consider animal welfare in determining the number of skeletons that could be exported, and that it had failed to consider animal welfare. And
David,
by failing,
I'm sorry to interrupt. We are at the 25-minute mark right now. So we're
thank you, Vivek.
30 minutes.
Great, excellent. Thank you for the warning. So I will continue with this, and we'll have a few other words. So and so the question was whether or not the government had a duty to take into account the effect on animal welfare of having so many lions bred for shooting, right? And they argue that the decision was unconstitutional and invalid because animal welfare was not taken into account. And importantly, you can see now the effect of the Constitutional Court decision. The High Court here in this case, the sort of lower court, right? Not a very low court, but a medium range court, right? They declared increased quotas for 2017 and 2018 unlawful on the basis that when one has regard to the connection between welfare interests of animals and conservation, which was mentioned in that Constitutional Court case, that it is inconceivable that the state respondents could have ignored welfare considerations of lions in captivity in setting the annual export quota. So the fact that they did not consider those welfare effects meant that their decision was unlawful, and therefore there was no quota that was set then. No one was allowed to kill their lions. Of course, they have subsequently done that, but now they have to be quite careful in the way they set those quotas. Okay, so it shows you, and of course they had to be reduced as well. So it shows you the effect of those decisions. Right, so I've told you about the Constitution requiring a changing approach of the law to animals. But that's not enough. There's a need to enshrine this through statutory reform and policy. There's a need to consider this link between human and animal rights. As I mentioned, the environmental right is a human right, but somehow respect for animals has been included therein. And statutory reform should enshrine a revised understanding of the worth of animals. This requires that both scientific and moral understandings of animals have shifted since the passing of the Animals Protection Act in 1962, and those changes need to be reflected in the legislation, and so there needs to be ultimately legislative reform to give effect to this change. The Department of Agriculture is currently drafting a law that seeks to reform existing animal welfare law in South Africa. Unfortunately, it's mainly driven by imperatives to export animal products to the EU, and South African laws not being updated, so it affects the ability to export animal products. That does, however, show that international context can have some kind of positive effect in creating a driver for positive change in relation to welfare. And basically, in the last 2 years, civil society organizations, one of them who I'm a director of, Animal Law Reform South Africa, and the Humane Society International, created a project to stimulate discussion of what should be in that law, and has engaged with the animal welfare sector and released a report that makes various proposals to improve the protection of animals in the law. And I won't be able to talk through this at length because we're running out of time, but those of you interested, we would really like you to have a look at that. You're all experts in this area, and would love you to get some input as to what you think, or if you know of best case examples of how to improve the law for protection of animals. Some of the key problems are identified in the report in relation to the current legal framework, the lack of recognition of sentience, vague notions of unnecessary suffering, limited fines, no specific regulations, and real problems with the actual enforcement structures, as well as the government structures, which are conflicted, as like the Department of Agriculture, which is supposed to support the development of agricultural industries and at the same time regulate animal welfare. And so some of the problems, some of the suggestions, and as I say, I can't go through these in detail now, but are to recognize animals as sentient beings with intrinsic value in the legislation that's arguably required by the Constitution, recognizing a duty of care of humans towards animals that includes not harming them and enabling them to flourish, presumption against causing harm or cruelty to animals, and then requiring any harm to animals to be justified according to the principles of proportionality. So kind of linking these ideas to human rights, right, in the way we apply to humans. And adopting a similar structure, adopting specific standards in particular areas through regulation on relation to things like testing, entertainment, food industry, prohibiting certain extremely cruel acts such as use of elephants in circuses, sow stalls, battery cages, moving animal welfare to the Department of Justice and creating a special animal protection office dedicated to policy around animals, enhancing the powers of prosecution for multiple organizations, and also enhancing transparency and reporting requirements in relation to animal use or abuse industries. So there's a lot to think about. I've just given a short summary here of a few of the recommendations. This is, as I say, it's a work in progress. It's meant to be discussed. There's now going to be a workshop in May to discuss some more and to hopefully build the animal protection sector's view on what should be in the legislation to try and create some kind of coherent pressure to improve the law in relation to animals. So as I've suggested to you, the status of animals was as objects or things, and the Constitution has brought about a shift in the whole legal system, and that raises a question of what should the status of animals be and what should their protection be. The Constitution has recognized that, Constitutional Court recognized they have intrinsic worth and value, but at the same time, billions of animals are killed in South Africa for food and kept in terrible conditions and live miserable lives. Trophy hunting continues unabated for entertainment. Animals are trapped. They are exported from South Africa by sea, living perilous lives. And so I would suggest we cannot be satisfied with high-sounding pronouncements. We need to work out what the concrete effects of these legal changes will be. And we must engage with the conflicts between animals and human interests in a way that animal interests will not always lose out. And realistically, we need to initially protect animals against the most intrusive forms of harm and ultimately aim to recast our relationship with animals towards a respectful relationship in which we live in harmony with other creatures. We also need to grapple with what is in fact an African global South non-exploitative ethic towards animals, not one that's just influenced by global North, but how to draw in a homegrown respectful idea and attitude towards animals. And this requires rethinking many aspects of the law. And as I've said, I would recommend having a look at the Animal Law Project report. And so I'm going to conclude with this wonderful quote from the from the Constitutional Court case, which basically says from the ancient Khoisan reverence of the eland to the contemporary conception of the dog as man's best friend, humans and animals have a storied relationship, right? Which one that is part of the fabric of our society, homes and lives. Animals have shifted from being mere brutes or beasts to fellow beasts, fellow mortals or fellow creatures, and finally to companions, friends, brothers, and sisters. So thank you very much.